Hello, my name is Audrey and I'm here with my sister Claire today to break down the facts and oral argument of Fellowship of Christian Athletes versus San Jose Unified School District, a Ninth Circuit religious liberty case.
Here are the facts. The Fellowship of Christian Athletes, or FCA, requires club leaders to affirm certain religious beliefs, including that sexual intimacy is to be expressed only within the context of marriage, and marriage is exclusively the union of one man and one woman.
This doesn't mean that gay and lesbian students can't participate in leadership, but they must affirm these views. Meanwhile, anyone can be a member. In 2019, the club was de-recognized for violating the school district's non-discrimination policy on the basis of students' sexual orientation.
In 2021, the district adopted an all-comers policy, which states that all students are eligible for club membership or leadership consideration regardless of their status or beliefs. Clubs can still use neutral criteria like participation or attendance to determine who gets to be part of their club, but they can't decide based on gender, religious beliefs, or race, for instance.
Here's where things get tricky. While the all-comers requirement barred the FCA from official club status, gender and ideology-specific clubs like Girls Who Code and the Republican Student Club, which requires leaders to support the Republican platform, were allowed to operate freely.
To add fuel to the fire, one group, the Senior Woman Club, explicitly stated on its application form that it would only grant membership to females. It was approved despite clearly violating the all-comers policy, though the district argues that it was a mistake.
Now, under the 2010 Supreme Court case Christian Legal Society versus Martinez, all-comers policies are constitutional. However, they have to be uniformly applied. Otherwise, they aren't really all-comers. So the question before the Ninth Circuit is the school district's all-comers policy in actuality all-comers, or does it unfairly target the FCA for its religious leadership requirements?
The Ninth Circuit heard this case last August before a 3-judge panel and cited for the FCA. After, the school district filed for a rehearing, this time en banc. That means a full panel of 11 judges heard oral arguments on March 23, 2023.
Lead counsel for the petitioners, Daniel Blomberg, argued that the evidence shows the district's policy wasn't truly all-comers, and moreover, that all-comers policies aren't practically achievable without harming student groups. Meanwhile, some judges expressed concern about religious animus or hostility against religion, as some teachers in the district used pejorative language against the FCA.
The question of standing, or the club's right to sue, also surfaced. To have standing, the FCA must prove that it suffered injury, like being refused recognition, under the school's policy. Though students never applied under the all-comers policy, that might have been because doing so would have been futile. And even if the club itself hadn't suffered injury, its umbrella organization, the National FCA, had acquired and would face ongoing costs, which could also constitute injury.
Lead counsel for the respondents, Stacey Layton, emphasized that the approval of the Senior Women Club, despite its explicitly stating that it would exclude male membership, was a mistake attributable to a lack of staff training. When the judges steered questioning back to religious animus, Layton averred that the teacher's comments, which were made in 2019, affected students who had now graduated. There wasn't evidence, she argued, of hostility against students currently enrolled in the district who might want to join the FCA.
A key distinction in this case is that student-run clubs, but not district-run programs, are bound by the all-comers policy. For example, a girls' soccer team run by the district would be allowed, but a girls' soccer club run by students would not. Some judges expressed perplexity. Why was sex-based discrimination valid in one scenario but not the other?
Layton explained that student-run clubs and district programs have different purposes. Through student-run clubs, the district aims to create a student-run forum to which all students have access. On the other hand, district-run programs have pedagogical purposes that can't be met with the all-comers policy. Still, some wondered whether there are better ways to achieve these purposes.
There are several routes the Ninth Circuit can take. For one, it can uphold the district's policy. Alternatively, it can order revisions to the policy to include the FCA or strike the policy down altogether. If the court rules that the club doesn't have standing, it doesn't have to consider the issue at all.
A ruling is expected sometime later this year. Meanwhile, we hope you enjoyed our overview of Fellowship of Christian Athletes versus San Jose Unified School District. Thanks for watching.